So welcome to our 2023 annual employee meeting for Cityscape related companies, Reliant and Fog City. I'm Nick Berg. I'm the president of Cityscape. Also on the call, we have Paul Mora, our vice president, Robin Romo, our chief operating officer, and Wayne Lee, our chief financial officer. We also have our directors here, Francis Serrano, Sergey Gorhovsky, and Joanna Lamb. And from Reliant, I believe we have Mark Owens here, the president of Reliant.
Morning, everybody.
All right. So thank you guys all for coming. And for I'm going to keep my comments brief because again, Paychex has a hard stop at 10 to do the harassment training. So I really just, in short, wanted to say it's been a great year. I know you guys have worked hard. Cityscape continues to be well regarded in our industry and in our market. And really that is all to the hard work and the care and the judgment in caring for our client communities. I just really appreciate what you do and the difference it makes for Cityscape and for those communities. Without further ado, I will introduce Natalie from Paychex, who will do our harassment training.
Hi, good morning. Thank you for having me today. We'll go ahead and jump right in. We have a lot of information to cover. My name is Natalie. I'm an HR business partner with Paychex, and today I will be presenting on workplace harassment in California for all employees. So bear with me. We have 60 minutes, lots of information to cover, and we'll go ahead and jump right in.
And I'm sorry, I'm going to pause you real quick. So everybody should have received in the mail a workbook. So we want you to pull out your workbook, and you're actually going to have to complete the answers and submit this. This signed work with the completed answers is the evidence of that you actually took the training. So please pull that out and fill it out. Sorry, Natalie.
No worries. Thank you for that reminder. All right, so let's go ahead and jump right in. Today, as I mentioned, we're going to spend the next 60 minutes together. I am not an attorney, so the information that we cover today is not to be considered as legal advice. And the information that we'll review really reflects the most current information at the time of the release. So let's go ahead and jump right in to the introduction of sexual harassment and what employment discrimination looks like in general. So it's important to understand that workplace harassment is a form of employment discrimination. And employment discrimination occurs when an employer treats employment decisions towards one person or maybe many people from a protected group differently than toward other similarly situated individuals. So discrimination occurs because of an individual's protected characteristic or their membership in a protected group, or maybe not being part of such a group. So employment discrimination violates Title VII of the Civil Rights Act, Age Discrimination in Employment Act, and the Americans with Disability Act, as well as other state and local laws. So some examples of employment discrimination can include refusing to hire an employee because of their race, maybe denying an employee the opportunity for training because the employer disagrees with their religious beliefs, or perhaps assigning an employee who is disabled some sort of tasks that would be impossible for them to complete, perhaps. Or maybe terminating a female employee because the employer feels a man would be better suited for the job, for example. Now, federal and state courts have ruled that harassment of all kinds is a form of illegal employment discrimination. So, in addition to sexual harassment, other forms of harassment are considered employment discrimination when they arise from unwelcome conduct that's based on legally protected characteristics. So, this could include, but of course not limited to, race, color, national origin, religion, sex, including pregnancy, age for anyone 40 or over, disability, or genetic information. This all means that to be unlawful or illegal, the conduct in question must create a workplace environment that would be intimidating, hostile, or offensive to any sort of reasonable person that would be similarly situated to the complaining party. Workplace policies on sexual harassment are largely based on federal and state statutory and case law standards. So let's kind of jump into those. As with employment discrimination, sexual harassment law principally is defined by Title VII of the Civil Rights Act and a number of important federal and state court cases. All 50 states have enacted laws against sexual harassment, and we will review information on select state laws later in the course. Periodically, a federal or state court issues a ruling on a case that further defines and advances our understanding of sexual harassment in the workplace. This is one reason that workplace policies may change to keep up with current and evolving definitions of sexual harassment. But as it stands today, the law defines sexual harassment this way: any unwelcome sexual advances or requests for sexual favors, or any conduct of a sexual nature. So according to the law, sexual harassment occurs when the conduct relates to a term or condition of employment, or agreement to engage, or maybe rejection of the conduct is used as a basis for making employment decisions, or the conduct substantially interferes with an individual's work performance or creates an intimidating, a hostile, or an offensive work environment. So to better understand sexual harassment, let's look at each of these factors. Sexual harassment involves unwelcome conduct. This means it's uninvited, uninitiated, or unwanted. Even conduct that is tolerated or participated in might still be considered unwelcome. Examples of conduct of a sexual nature would include sexual advances, requests for sexual favors, and any other sexually orientated verbal or physical conduct. If unwelcome conduct of a sexual nature is sufficient to interfere with somebody's work performance or negatively affects the work environment, it may meet the definition of sexual harassment, whether or not it was intended. Examples of conduct that is quote unquote of a sexual nature include, but are not limited to, unwelcome sexual advances, suggestive or lewd remarks, maybe unwanted hugs, touches, kisses, and of course, requests for sexual favors. Harassment involves conduct that affects somebody's employment, including any of the following: their agreement to engage in or request for sexual favors as the basis for making employment decisions, rejection of an offer of sexual relationship, which could maybe lead to being denied an employment benefit, or other sexual conduct that interferes with somebody's work performance or creates a hostile work environment. This is a form of sexual violence that includes any any involuntary sexual act in which a person is threatened, coerced, or forced to engage against their will. It also consists of non-consensual sexual touching of a person. So sexual assault is particularly a risk for employees performing solitary work, because perpetrators can use the isolated location to take advantage of a targeted person, not necessarily the case in remote work environments, of course. Historically, sexual harassment has been a problem in the workplace, and it remains so today, which is why we're spending an hour together talking about it. But you might wonder, how common is sexual harassment? So let's kind of review some stats to understand how its pervasiveness affects maybe you or your coworkers. So with that being said, 81% of women and 43% of men have experienced sexual harassment. 77% of women experience verbal sexual harassment. 51% have been sexually touched without their permission, and about 41% said that they had been sexually harassed online. With that being said, 75% of those victims claim retaliation or employment-related punishment when they report sexual harassment in the workplace. And still, at least 87% of those experiencing harassment do not even file a formal complaint. So that's an example of why you can see why it's such a big deal. So can you identify the likely consequences of sexual harassment by reviewing these examples? And the reality is that many harassers don't consider the impact on the offended party's feelings. So all of the above are negative results of harassment. Next, I want you to think of the negative effects of harassment. What are the negative effects of harassment on individuals that are subjective to it? People who feel like they've been harassed could feel all of the responses of the negative effects here. Sexual harassment can have a traumatizing effect on individuals subjected to it and negatively impact them in many ways that could be seen or unseen. For individuals who are rightly or wrongly accused of sexual harassment, the consequences can be significant. Investigations of and the punishment for harassment take a high financial and physiological toll on those who are accused. So when someone is implicated in a harassment investigation, the investigation often is very expensive and mentally draining. Incidents of harassment, even frivolous claims, take a toll on the personal and professional reputation of the accused. And these types of incidents could destroy relationships, damage careers, as we've seen in Hollywood, and cause unwanted notoriety. Now, the organization has no tolerance for harassment of any kind in the workplace, and it takes these allegations seriously and will not hesitate to discipline someone who is found to have engaged in offensive behavior, whether or not the conduct ultimately is determined to be illegal harassment. Another thing that's important to know is that managers can be personally liable for incidents of harassment. This means a complaining party can sue the manager personally, in addition to the employer, and each could be responsible for financial payments to the person that was subjected to the harassment. So that's a big deal. Now, while we may intend that what we say or do is harmless, we cannot always know the impact on others. So we should try to ensure that they do not interpret our actions as questionable or improper. So remember, in determining whether harassment has occurred, the focus is not on the intent of someone's conduct, but rather the impact on the person that's experiencing the conduct. If uneasiness or concern with others arises, ask yourself, what just happened? How is the outcome different from what I intended? And where can I take responsibility? By considering these questions, you can clarify the situation and correct any misunderstanding. But understand that one's intent is not by itself a defense against any charge of harassment. So a little bit of an exercise, someone who engages in conduct that others may view as sexual harassment runs the following risks. The first four responses indicate the risks that someone who engages in harassment may face. As you can see, it's important for everyone to assess their conduct and stay clearly away from any behavior that can be reasonably perceived as harassment. So let's switch gears to talk about hostile work environment, sexual harassment. Of the two forms of sexual harassment, hostile environment sexual harassment is by far the most common of the two. This occurs when someone is subjected to unwelcome and offensive sexual conduct that meets either of these conditions. One, it unreasonably interferes with their work, or two, it creates a hostile work environment. Sexually related conduct, including anything that affects somebody's ability to perform their work. This might include, but is not limited to, creating stress or anxiety that affects an individual's ability to concentrate on their work, or perhaps blocking or stalling someone from returning to their work. Sexually related conduct that makes that individual uncomfortable in the work environment can make it more difficult to do their job. So some effects of hostile work environment could make an individual uneasy about working with certain coworkers or coming back to the workplace, or it could make somebody depressed about the workplace in general, excuse me. So think about written forms of hostile work environment harassment. Be aware that there are various forms of harassing conduct, and think about different forms of written conduct that might involve harassment. The first three actions are inappropriate in any workplace, and the last item is not sexual in nature and therefore might be appropriate for the workplace. Now, in terms of verbal forms of hostile environment harassment, as you can see, there are various forms of speech or verbal sounds that can be involved in engaging sexual harassment. The final action is unlikely to create a hostile work environment because it relates to somebody's appearance as it relates to their role in the workplace. Here, when we talk about visual forms of potential hostile environment harassment, the first three actions are inappropriate in the workplace, and the last item is not sexual in nature and therefore appropriate for the workplace. And then when it comes to physical or actionable forms of hostile environment harassment, the first three actions are inappropriate in the workplace, and the last two items may not be intentional and or sexual in nature. So what type of questionable conduct creates a hostile environment? The law examines this type of misconduct using certain tests developed in real cases. So to determine whether misconduct is unwelcome, offensive, and of a sexual nature, the misconduct must meet the following standards. The reasonable person standard is used to determine whether specific conduct may create a hostile environment. This standard suggests that the conduct must be offensive to any reasonable person working in the same environment as the individual making the complaint. Generally, a pattern of misconduct needs to exist to be considered as illegal hostile environment harassment, but under the law, trivial, infrequent, or occasionally annoying sexual conduct is not sufficient to create a hostile working environment. So although there usually needs to be a series of incidents, one particularly severe incident could qualify. Unlike most states, California has established a different standard regarding what constitutes a hostile environment. So under California law, conduct need not be severe or pervasive to constitute harassment. So in California, misconduct that so alters working conditions as to make it more difficult to do the job is sufficient if the conduct also meets the other conditions of harassment. So this means that even one minor incident can constitute harassment so long as the targeted person can show that they had a more difficult time working in the environment following that incident. What ways could someone try to rationalize their conduct that many others may perceive as sexual harassment? Well, the reality is that all the checked items could be used to rationalize questionable or improper conduct. So be on the lookout for them, both in your own conduct as well as that of others. Which of the following are examples of hostile environment sexual harassment? Hostile environment sexual harassment occurs when unwelcome written, verbal, physical, or visual conduct of a sexual nature alters the condition of an employee's employment. So if a coworker asked another out for a date just once and they declined and work life proceeds as normal, that would not be an example of hostile environment sexual harassment. Now let's talk about quid pro quo sexual harassment. Quid pro quo sexual harassment occurs when a manager makes or offers to provide an employment benefit based on whether someone reporting to them is willing to trade sexual favors or romantic dates for the benefit. This benefit can include the following: maybe a promotion, a desired job or project assignment, perhaps a raise or a bonus, or maybe avoidance of being fired or laid off. The manager does not need to directly manage that individual as long as the manager has some influence over that individual's job or employment conditions. So someone elsewhere in the organization chart can potentially engage in this harassment. Quid pro quo harassment also occurs if an individual rejects their manager's sexual request or advance and is then penalized for this. So to avoid quid pro quo sexual harassment, it's good to recognize the signs. Which actions listed here are likely quid pro quo harassment? The last three actions imply or indicate a job action benefit or penalty based on a romantic or sexual favor. The romantic or sexual favor is requested or implied by a manager who has authority or influence over the other person. Given that quid pro quo sexual harassment depends on somebody in authority abusing their power, such conduct comes with risks. So managers not only need to manage their own conduct, they should understand how to manage how others managers may put the organization at risk as a whole. So in some states, such as California, when a manager engages in sexual harassment, the employer is liable regardless of whether the employer knew of the conduct. This is because a manager is an agent of the organization and therefore is acting on its behalf. In other states and under federal law, the employer will be liable for harassment if the employer knew of the conduct and failed to take immediate and appropriate corrective action, or should have known of the conduct and just failed to exercise reasonable effort to prevent the conduct from happening. As mentioned earlier, a manager or a supervisor can influence what happens to staff because they have authority over the staff's employment. So staff may submit to a manager's directive because they feel it's necessary to perform their assigned job duties. They want to please the manager. They want to follow the manager's directives to avoid consequences. They're influenced by the manager's charisma, position, or the authority. So managers must use caution when interacting with their staff to not convey any order, directive, or other communication that suggests a job benefit in exchange for a romantic or sexual relationship. All right, so let's talk about Magdalena and Kevin. Magdalena gives Kevin a raise. After he gets the raise, she says he owes her a quote unquote thank you, since he really hadn't yet met all the conditions for the raise. So she suggests a weekend trip together. Is this quid pro quo sexual harassment? Yes. Magdalena is taking advantage of her authority and pay raise in hopes that Kevin will engage in a romantic relationship with her. This means that she opened herself and the business to a claim of quid pro quo sexual harassment. Other types of harassment are illegal, including those quote unquote based on sex. This includes conduct that is specifically sexual in nature, but deals with a person's sex or gender. This type of harassment, as well as discrimination, is considered illegal as a form of sex discrimination as a protected class. So the specific forms of harassment relate to sex stereotyping, gender identity and expression, sexual orientation. Now, sex stereotyping occurs when individuals consider a person's conduct or personality traits as inappropriate because they may not conform to the other's perceptions about how individuals of either sex should act or look. So, examples of perceptions that can lead to sexual stereotyping could be from another person's perspective, an individual's look, speech, personality, or their lifestyle do not conform with or match perceptions of the individual's sex or gender. It could also be maybe that an individual performs a job that others consider usually or mostly performed by the opposite sex. Gender identity and expression. This is a person's identification as male, female, or both, or maybe even neither. So the term transgender involves identifying differently from the sex of the person, the sex that the person was assigned at birth. Gender expression sometimes is considered a part of gender identity and other times is considered as separate. So gender expression means that someone's gender-related appearance and behavior, that's what we're referring to. This is true regardless of whether the expression is stereotypically associated with the individual's assigned sex at birth. And some examples of gender expression are evident in maybe somebody's choice of clothing, their hairstyle, their choice of accessories, maybe their behavior, their movement, and their speech. And then we have sexual orientation. So the Human Rights Campaign defines sexual orientation as an inherent or a mutable, enduring emotional, romantic, or sexual attraction to other people. Note that an individual's sexual orientation is independent of their gender identity. So sexual orientation refers to someone's attraction to a specific sex or gender, more than one sex or gender, any sexes or genders, someone lacking gender, or no one. Following recent changes in the law, it is illegal to harass an individual due to their sexual orientation or on the basis of gender and gender-related traits in all 50 states and US territories. So this is true whether harassing comments or behaviors are about a person's sexual attraction to others, including to the opposite sex, the same sex, both sexes, and no sex. So thinking about sex-based harassment and the different types of forms of sex-based harassment, which of the following forms of sex-related conduct does each example represent? all situations describe sex-based harassment. And as you can see, sex-based harassment can clearly take many forms. All right, so let's talk about sexual harassment and third parties. Individuals outside of the organization also can engage in harassment of the staff. So this can include customers, contractors, any vendors, so on and so forth. Third parties include customers and people working with us, but for a different employer, maybe like the security staff, IT, business partners, staffing agencies, help desk call centers, janitors, maintenance, delivery service, maybe even visitors like interns or external inspectors, suppliers. You kind of get the gist of where I'm going with the third party harassment. So harassment involving third parties can occur where we work, where we meet with third parties, or anywhere else that we come in contact with them when working. Harassment is more likely to occur if we work directly with customers and feel a duty to please them. The organization is committed to safeguarding all of us and can be held liable for the harassment of staff by third parties. So it's important that everybody raises concerns regarding harassment by anyone. Likewise, each of us should treat third parties respectfully and not engage in any sort of conduct that reasonably can be considered as harassment. All right, which of the following is likely to involve sexual harassment by a third party? The three yes responses all involve a third party's inappropriate, illegal, and harassing actions. Let's talk about other hostile environment harassment. Harassment can occur for a protected category other than sex. So race refers to one's racial group. This includes whether a person actually belongs to that race or merely is related to it. So for example, by association through the person's name or maybe through marriage. Race also includes race-linked characteristics, maybe hair texture or facial features, skin color. And race is a protected class. National origin refers to the country or the region where someone's born or from where their ancestors come from. And it covers all related physical, cultural, and language-based characteristics. Religion refers to one's deeply held religious beliefs and practices, and an organization or employee can be liable for discriminating or harassing someone based on their membership in any religion, even if it's a non-traditional religion or a lack of a religion. So as long as that person's beliefs are sincerely held. Age for people over 40 or 40 and over, I should say, are protected from discrimination and as a result, harassment in the US. It's important to remember that younger people are not protected in the same way. Disability harassment occurs when a person who has a physical or mental impairment that substantially limits at least one major life function or activity is subjected to a hostile working environment due to this impairment. Disability as a protected class also includes a person who has a history of impairment and a person who others may just believe is disabled. Harassment against military veterans can occur, for example, when someone's harassed because of their military service due to certain mannerisms, maybe that they acquired during their service or due to a disability related to their service. Harassment based on genetic information includes harassing conduct related to an individual's or a family member's genetic tests and medical history. And states and other municipalities have added other protected categories from harassment and discrimination that are determined to be inconsequential to someone being able to perform a job. These categories are inconsequential to someone being able to perform a job in the sense that, as mentioned earlier, harassment also can occur against someone for another protected category other than sex under US federal law. Other protected categories, to your no surprise, could be, religion, age, race, color, disability, veteran status, genetic information, so on and so forth. So when we talk about harassing behavior, all but the second item involves someone's harassing behavior towards someone else due to that person's protected characteristic. Okay, so let's talk through this scenario. During meetings, Melody comments whenever her coworker Winnie, who immigrated from Nigeria, wears a gili, a form of a head wrap that's traditionally worn in her native country. She uses comments like, "Oh, a white girl like me could never get away with that look," or "Wearing that thing, you could win the title of real ethnic American." As a result, Winnie expresses her discomfort in working with Melody. Do you believe that this type of conduct described would be non-sexual hostile environment harassment? It could be. And it's important to know that what conduct is appropriate and positive or involves harassing someone based on race or ethnicity. So just be mindful is the takeaway here. Let's talk about addressing harassment. It's important to understand that harassment is taken seriously. We cannot be absolutely certain that harassment does not occur in the workplace, but it is a communal responsibility to take the steps to maintain a workplace where everyone's treated respectfully and harassing conduct is addressed and mitigated. The workplace maintains several resources to help all staff and others address concerns about harassing conduct. These resources are provided later in this presentation, and we can consult with these resources with questions or concerns, comments, so on and so forth. Once you or someone else raises a concern of harassment to a manager or other resource, the organization has a legal duty to investigate and take prompt and effective corrective action. Failure to respond promptly and appropriately can lead to legal liability. So if you bring a complaint of harassment to the organization's attention, your manager knows that they're expected to treat it seriously and handle it according to our policy. So these are examples of why speaking up matters. Why is it important that we raise concerns about harassment? Because coworkers may suffer from similar conduct if it's not addressed. And if it's not addressed, the person that's engaging in the improper conduct may feel that they can continue to act that way. And also, the organization faces liability if it doesn't correct misconduct that it should reasonably know about. So the yes actions help maintain positive, welcoming, and safe workplaces. Please review this information for guidance about what to do if you have a concern regarding possible harassment. I feel like this is where a lot of employees get stuck and may be concerned about speaking up. Generally speaking, you don't have to speak to the individual engaged in the harassing conduct if you don't feel comfortable doing so. You can raise a concern in other ways. So if one option is not available or ineffective, try another. Maybe you can select the following to explore your options. If you have time, these steps can prepare you to raise a concern, and that will help the concern to be promptly and effectively resolved. Now, it's not required that you take these steps, especially if you think it's urgent to just raise the concern, but you could request a meeting with your manager or HR, and they can focus on your concern. If you do that, be ready to describe the facts of the situation to assist management in looking into the matter. And you can identify the standard or policy that you believe has been violated. Ensure that your report is made in good faith, meaning that your report is true to your knowledge and that it's not made to get revenge against somebody, because your manager is responsible for helping you address any concerns of questionable or improper behavior. Now, other managers are responsible for helping with concerns of improper behavior. If you're a manager, let's say, is not available, they're out of the office, or maybe the concern involves your manager, you can always contact another resource within the organization. This is what you can expect when you raise a concern with your manager or another manager or any sort of resource HR internally. Of course, your concern will be taken seriously. Your concern will be investigated. The organization will take action if misconduct is identified, and you will most certainly be protected from retaliation. The organization's serious about its commitment to address improper conduct, and any sort of report that you make is important to Cityscape. You may be asked for additional information to assist in an investigation, and you are obligated to treat your report and knowledge of the investigation as confidential. Because of confidentiality reasons, Cityscape may not be able to provide you with details regarding its handling of your concern. So know that the organization's committed to taking responsible action to discipline those who violate its policies and correct this misconduct. Disclosure of your report of suspected misconduct will be limited to those who need to know as part of an investigation and a resolution. So know that it might be necessary to disclose information that has been obtained in the inquiry to complete the investigation and take appropriate action. So in California, this type of concept is something that we refer to as quote unquote limited confidentiality. If you believe that you are subject to retaliation, please report it to management or HR. Management cannot see everything that occurs. So if you believe you have been subject to retaliation or any sort of like bullying for your report, you should notify management or HR, any internal resource that would be appropriate in this case. So what about when you witness questionable behavior by other people? Should you do anything? let's talk about bystander intervention. Studies have found that individuals who witness suspected misconduct may fall under what we call the bystander effect. And this effect shows that witnesses tend not to take action regarding their observation for a number of reasons, which could be that they don't want to get involved in someone else's affairs. If they don't observe any other witness taking action, they assume the behavior must be acceptable. They assume another witness is more qualified maybe to address the concern, or maybe they already addressed it, or maybe they doubt the truth of what they saw. So the question becomes, should you intervene when you observe someone harassing another person? I mean, my first piece of advice would be to determine whether it is safe and appropriate for you to intervene. And if you don't think that you can intervene in a situation where someone's abusing or acting offensively towards another person, then seek guidance from a resource internally, management, HR, whoever you feel comfortable. If it is safe to intervene, a first step that you can take is to diffuse the situation. So think about the following techniques. You could call the individual subjected to the improper conduct away from the situation. Hey, Natalie, come on over here. Or you could interrupt the situation with an unrelated issue just to simply diffuse any tension. You might ask something like, oh, has anyone seen the president or senior leadership in a minute? If appropriate, you should consider letting the person engaged in the conduct know that their conduct is not appropriate. So you might say, hey, this is not the right tone for the workplace, or hey, I don't appreciate the approach that you're taking here, and I don't think that others do either. Or you could say something as simple as your actions don't meet our workplace values. Or you could call them out and say, hey, it seems like apparently you're upset. Your actions don't demonstrate respectful conduct towards others, so we need to end the conversation here. Now, after the situation is de-escalated, then you can inform the target of the conduct that you want to help them. You can serve as a witness and assist the targeted individual with reporting the conduct. And as agents of their employers, managers do have a duty to address instances of harassment whenever they occur. So let's talk about non-retaliation. A principle of concern for anyone who raises a concern or assists in its handling is suffering retaliation for their efforts. People would rather not speak up in many cases because they don't want to be retaliated against. And research finds that many people share this concern. Retaliation occurs when an employer or a manager adversely affects the job conditions of an individual for raising a harassment concern or participating in an investigation. This is called an adverse employment action. So even if no harassment is proven, a retaliation claim could follow if the victim or the witness claim that they suffered an adverse employment action due to their role in raising and addressing the underlying complaint. So examples of adverse employment actions could include a poor performance review, disciplinary action, a demotion in title, denial of a raise or a bonus, or directing others to ignore this person. Many ethical, legal, and financial reasons exist for preventing retaliation. So retaliation toward anyone for raising a concern is illegal and also violates policy and is contrary to whatever, the organization believes in. So not only is retaliation wrong, it discourages others from raising concerns, and this means that problems don't get identified and resolved. Cityscape's committed to a retaliation-free workplace for individuals who raise concerns about questionable conduct in good faith and who assisted its handling. State and federal laws also protect individuals from retaliation, and Cityscape is committed to abiding by these laws. So anybody who suspects retaliation against an individual for raising a concern has an obligation to speak up and report it. Also, managers have a responsibility to ensure that retaliation does not occur. So if such actions do occur, the individual should promptly report this to senior management or a person designated by the organization's policy, so HR. All right, let's talk about Heather. Heather learns that one of her staff is creating workplace discord by raising his third concern about harassment regarding an executive. In response, Heather gives this individual a poor performance review for creating workplace problems due to the complaints, resulting in a pay cut. Could this be an example of retaliation? The answer is yes. It doesn't matter who the employee raised a concern about. Any sort of adverse employment action by a manager in response to an employee's harassment complaint is retaliation. If the concern was raised in bad faith, this matter should be discussed with an appropriate resource like HR. Okay, let's talk about abusive conduct. Abusive conduct involves malicious workplace behavior that a reasonable person would find as hostile, offensive, and unrelated to the organization's legitimate business interests. Abusive conduct need not be related to a protected category. This behavior sometimes is just called bullying. And although it's not always illegal, all forms of bullying in the workplace are unacceptable, and California is one of those states that require that all employees be trained on abusive conduct. Note that abusive conduct is not the same as harassment, which would require offensive behavior based on a person's protected characteristic that we reviewed earlier. All right, so on your screen, you can see certain actions that are likely considered to be bullying or what we call abusive conduct. Obviously, verbal abuse, derogatory remarks, a pattern of intimidating or humiliating remarks, so on and so forth. Preventing abusive conduct is a priority within Cityscape, and the following tactics summarize an effective prevention strategy when you suffer or witness abusive conduct in the workplace. So first things first, examine your own behavior and refrain from engaging in conduct that is or could be perceived to be intimidating, humiliating, or threatening. Confront an abusive person in a calm, non-threatening, and objective manner. Abusive conduct is often tied to power, so making it clear up front that the negative behavior will not be tolerated may put a halt to it. So you could say, please lower your voice, shouting's not productive, or putting someone down in front of others is disrespectful. You could also deflect a verbal attack or aggressive posturing by simply just excusing yourself with a response similar to saying, oh, I was just on my way out. Perhaps we could talk later, or I have business to attend to. I'll get back with you later. Also, document each incident. So include when and where it occurred and any witnesses that were around, so that a pattern of this behavior could be established. And if you witness or experience abusive conduct in the workplace and you're uncomfortable confronting the perpetrator or your efforts to stop them fail, of course, seek help from a trusted manager, HR, or any other resource internally. All right, let's talk about workplace relationships. A romantic or sexual relationship between a manager and their subordinate can lead to accusations of favoritism, of course, or abuse of authority by other employees during the manager and subordinate's relationship, or by the subordinate when the relationship ends. And it may appear to be consensual relationship, but things can quickly change when the relationship ends. Generally, it's not a good idea to put yourself in a position where an inappropriate conflict is the appearance. And managers are advised that relationships with subordinates are inappropriate and certainly should be avoided. They might even be prohibited and discouraged by Cityscape's policy. So please understand your policies internally. Be careful regarding these relationships between coworkers, especially when working together closely. Ensure that all behavior is fully consensual. If necessary, talk with the manager who's there to help. In thinking about romantic situations, ask yourself, would these romantic situations cause problems in the workplace? All but the second situation most likely would create problems in the workplace. Okay, what can you do to prevent harassment? Creating a harassment-free workplace involves steps we take together to prevent harassment. We should all foster a civil and respectful workplace. Everybody deserves to feel a sense of belonging and feel safe when at work. Working together can be challenging at times, as we know, with differing opinions and disagreements, maybe sometimes conflicts and all other difficulties, but you must be respectful. And the more that we understand and appreciate the importance of diversity and inclusion, the better we can help create a respectful workplace. If harassment is unchecked, it might escalate, and it even could progress to assault, such as sexual assault. Cityscape's committed to keeping you safe at work, and if you are curious about what the organization does to keep you safe, ask your manager about safety procedures, and of course, report any sort of inappropriate behavior immediately. To maintain a respectful workplace and safeguard against harassment occurring in our workplace, all but one of the actions on your screen helps maintain a harassment-free workplace. And we'll move into liabilities and remedies for the last 5 minutes here. Cityscape takes harassment seriously, so does the law. It's your job to understand the consequences for those who engage in harassment. Any staff who engages in harassment or otherwise violates policy on conduct in the workplace may face corrective action or even termination. Managers and supervisors are agents of the organization, as we discussed. Therefore, they're acting on behalf of the organization and almost always subject the organization to liability when they engage in illegal conduct. In some states, when contractors engage in harassing conduct while working for the employer is liable if it does not take prompt or corrective action after learning of the harassment. While remedies cannot make up for any severe damage that harassment causes, employees can at least know that the government does all that it can to protect employees. Employees have a variety of remedies available under federal law, including making a complaint with the U.S. Equal Employment Opportunity Commission, the EEOC, or the applicable state human rights or fair employment agency. And employees who successfully pursue a complaint might be entitled to the following: maybe monetary damages if the employee left the organization due to the harassment, maybe they're rehired, promoted, reinstated, maybe back pay, compensatory damages, the list goes on. Penalties that employers might be liable for could be community service requirements, submission of compliance reports, public posting and publishing of liability for harassment or discrimination, potential criminal penalties, the list goes on. Other potential remedies exist for individuals subject to harassment, but those identified here are the most common. While none of the available remedies can make up for any severe damages the harassment caused, employees can at least know that the government does all that it can to protect employees. In addition to filing a complaint in the workplace, an employee can file a complaint externally if it's not addressed. Initiating a harassment claim in a state begins with a complaint to administrative agency, like I said, and the complaint must occur within a set amount of time following the alleged misconduct. The complaint can be filed with any of these agencies and does not need to be filed with all of the agencies if, when filing the first claim, the reporter elects to quote unquote cross-file with other agencies. After submitting a complaint, an employee can allow the administrative agency to investigate the matter and determine whether cause exists to move forward, or in times even request a right to sue letter to bypass much of the process. To file a claim of harassment or discrimination with the EEOC, you have to take action to contact, those listed on the screen. However, I will say that Cityscape does take this seriously and is, in terms of the series of events, the issue can be resolved a lot quicker if it's brought to the attention of management or HR internally. As you know, harassment is illegal in this jurisdiction, so please review the contact information shown on the screen for filing a claim of suspected harassment or discrimination. And again, Cityscape asks that you raise your concerns within the organization to the resources provided to you, a trusted manager, HR, whoever it is that you feel comfortable. If you have questions or feedback about this training, please feel free to email us based on the email address on your screen. Thank you so much for sticking with me for the last 60 minutes to talk about sexual harassment prevention in California. I will encourage you to look at your policy internally to better understand, the details throughout. And thank you for joining me, having me join your meeting, and I hope you guys have a good rest of your day.
Thank you so much, Natalie. We really appreciate it.
You're welcome.
All right. So the workbook, unfortunately, didn't perfectly line up. I think they updated the training. So let's go through the workbook questions real quick, and then everybody needs to sign the workbook at the end, and because again, the workbook is evidence that you completed the training. So if you don't sign it and return it, Capri is going to track you down. So Natalie, it's okay if you want to drop off.
I do have a hard stop, so I am going to jump off, but if you have any questions, let me know. Thank you, guys.
Thanks, Natalie.
Appreciate it. Right. So, true or false, volunteers and unpaid interns are not protected against sexual harassment. You guys can go off mute if you want.
I'm sorry. We used to have an electronic version. I threw my paper copy away.
Ooh.
Do we still have an electronic version?
No, failed.
No.
There's one attached to the.
Sergey, Capri
I
sent
will-
one out.
I'm sure I'll hear from Capri about it. Sorry, guys.
Sergey, Capri emailed one out yesterday.
Yeah, I sent it to HQ yesterday.
Yep.
Let me know.
I downloaded one from the invite.
Oh yeah, it's probably in the invite as well. Okay. So, what do you guys think? True or false on this one?
False.
False. Good. Okay. True or false? Individuals can be personally liable for sexual harassment.
True.
True.
True or false? help identify specific protected basis for employment discrimination, harassment, and retaliation.
True.
That is true. California FEHA prohibits discrimination and harassment based on several protected characteristics, in addition to protected characteristics under federal law.
True.
True. What does FEHA stand for?
Federal
It is
B.
B. Which of the following is a potential negative impact of workplace harassment?
D.
D, all of the above. True or false, both employees and applicants are protected under the anti-discrimination laws enforced by EEOC. True. Which term best describes a situation where an employee is a victim of discrimination, including harassment, and the conditions are so bad that they're compelled to resign? So she didn't really specifically talk about this, I think, but it is called constructive discharge.
No.
Think back to the example of Tommy, who is relied upon by his manager, Sue, to mentor employees. Last 3 times a promotion opportunity came up. Tom applied, but the promotion was given to one of the female employees Tom is trained. Could this scenario also be considered harassment? Good one. I don't see anything specifically that would suggest harassment. But I think it could be,
False.
so I think they go to.
Is it true?
All right. I think that one's so vague. Capri, do you have an opinion on this one?
I agree with you. I would say true because it could be
It
harassment.
could be.
Discrimination.
Yeah. Okay. True or false, sexual desire is a key element to any claim of sexual harassment.
False.
False. Okay, I'm gonna page of this. Okay. True or false, an employee can file a claim of sexual harassment even if the supervisor took no adverse employment action.
True.
That's true. Blake, the sole proprietor of Acme, has decided to expand and compete for state contracts. Blake hires Jack to install a computer network. Blake threatens Jack for breach of contract unless Jack agrees to engage in sexual activity.
D.
D.
E.
That is quid pro quo. That is a this for that exchange that he's trying to propose. Who is typically the perpetrator of a quid pro quo harassment?
Persons with authority.
Hey, that's really impressive. You didn't even have a multiple choice there. It is persons in authority. True or false? Quid pro quo sexual harassment can be based on a single event.
True.
True.
You and Chris have been good friends for 3 years. You've dated on several occasions. Last week, Chris was promoted to director. Chris is not your direct supervisor, but is the head of your division. Chris stops by your office and asks you to dinner. Concerned about how having dinner with this new director may look, you decline. Chris leans over your desk and states, if you do not want to be promoted to supervisor, or if you want to be promoted to supervisor, it's in your best interest to go to dinner with him. This scenario, is this a situation of quid pro quo or a hostile work environment?
Quid pro quo.
Your work area is a back office operation that's hectic. Men and women both refer to each other using derogatory terms. One of your coworker visits the website every morning and shouts out the joke of the day, which is always of a sexual nature. Most of the workers participate, but a few seem uncomfortable. Is this quid pro quo or hostile work environment?
Hostile work environment.
All right. True or false? To prove hostile work environment, sexual harassment does not need to know that they suffered an adverse employment action.
True. True.
I'm gonna go with false. I don't think it matters that the complaining party shows that they had a adverse employment action. I think you're gonna have, for example, the previous example where it's just a very people using derogatory terms and shouting out inappropriate jokes, and if nobody got demoted, it can still be a hostile work environment.
So it's true.
Would mean that it was true then, because
Oh,
it
it
says
means
that
it's
they
true.
do
Sorry.
not
All the
need
negatives.
to. Yep.
Got it. Yes. Sorry, I got the negatives wrong there. Okay. Does not need to show. Good. All right. To prove hostile work environment, the complaining party must show that they were subjected to unwanted sexual attention that was both severe and pervasive.
Oh.
Good. False. A male employee can be the victim of sexual harassment.
True.
Harassment can occur where both individuals are the same sex.
True.
Does sexual desire have to be the underlying reason for sexual harassment?
No.
No.
Is asking a coworker out on a date considered sexual harassment?
No.
No.
It is not, but don't quit. If you get a no answer, don't keep pestering the person, then it becomes harassment. Pro bono is the left phrase used when a person of authority demands sexual favors in return for a promotion or other job-related benefit.
False.
False. That is quid pro quo. Under California state law, an employee, applicant, unpaid intern, volunteer, or persons providing services pursue a hostile work environment. True. How does Civil Rights Council define gender identity?
A.
I believe that's A. Capri, am I right on that?
Yep.
The following might be a remedy in an employment discrimination case.
A.
D.
D, all of the above. How long from the date of the alleged violation of the California Fair Employment and Housing Act may an employee file a complaint with the California Civil Rights Division?
3 years.
3 years, yeah. I don't know if they went over that, but yeah, it is 3 years.
All right. Home stretch.
Thank you.
If you observe harassment taking place in the workplace, it is best to let the people involved resolve it between themselves. It's none of your business.
False.
Wow.
False. True or false? If you honestly do not intend to offend anyone, your behavior cannot be considered harassment.
False.
If someone lets you know that your behavior makes them uncomfortable, you should stop that behavior immediately and not engage in that behavior again.
True.
True.
Ooh. Fill in the blank. If an employee witnesses a potential harassment situation,
D.
C.
D. All right. Please sign and hand that into Capri when you get
Yes.
a chance.
You can scan it and email it to me. Please also complete the first page with your name as well.
Where's the copy? I don't have a copy of it.
Oh, I emailed it to everyone on Wednesday and okay. I see
Capri,
it.
yeah, why don't you email it out to AU Field and Reliant, just so that everybody has it.
Sure.
Thank you.
All right. Sorry, guys, that went a little bit long, just because again, the workbook didn't match up, but we'll hopefully sort that out going forward.